Workers in the United States were dealt another blow this week as the GOP succeeded in using the Senate filibuster to block the passage of the Paycheck Fairness Act. Now, the legislative filibuster, of course, would require 60 senators to vote in favor of any piece of legislation. And of course, the final vote fell short of that. Senators voted 49-50 to try to advance the legislation, falling short of the 60 votes needed to overcome the procedural hurdle. Now, of course, there are 50 Democratic senators in the Senate. So I'm sure some of you might be wondering, why were there only 49 votes? Well, Democratic Senator Kirsten Gillibrand decided not to show up for the vote, which is strange considering women's equality tends to be the issue she's tethered herself to in order to campaign. But nonetheless, let's move on to why this is so disastrous. Now, the Paycheck Fairness Act didn't get much attention. This vote didn't get much attention. But I suspect the reason why it didn't get so much attention in the lead up to the vote is because of the way Democrats messaged on it. They made it seem as though the Paycheck Fairness Act was just about gender. It was just about ensuring that men and women get paid the same. And to be fair, that was certainly part of it. But this bill really did have a positive, universal impact on workers. And I feel like their messaging should have focused on that, and people would understand the importance of actually passing this bill. So first, let me just go to a video of Democratic Senator Patty Murray, who explains exactly why it's important to pass a bill like this.
Right now, an employer can brush aside reports of pay discrimination by saying things like, quote, well, he was a better negotiator, or they work in different buildings. I mean, what does that have to do with it?
Exactly. What does that have to do with it? I mean, oftentimes when we hear about, pay differences and all that, this nonsense about, well, you're probably not a good negotiator. You probably didn't do this. You probably didn't. Just all this nonsense that actually has nothing to do with a worker's qualifications or a worker's skills. And so this bill focused on mitigating that kind of strategy or talking point that you get from employers who engage in unfair pay. So what would the bill do? The bill would limit employers to bona fide factors such as education, training, and experience when justifying pay differentials in wage discrimination claims. That means that negotiating tactics and other nonsense could not justify unequal pay between two employees with similar seniority who work the same job. Also, there was another important part of the bill that didn't really get much attention. Certainly, Democrats didn't message about it much, but it stated that employers would also be prohibited from retaliating against workers who compare salaries and barred from inquiring about prospective employees' salaries histories during the hiring process. So just think about that for a second. First off, it's already illegal to retaliate against employees if they disclose what their salaries are, but employers retaliate anyway all the time. I'll get to that in just a minute. But the second part of that is really, really important because oftentimes when you apply for a job, you are asked what your previous salary was. And based on your previous salary, the employer that you're applying to work for decides how much to pay you. Think about the amount of millennials who graduated into the economic disaster of 2008 and how difficult it was for them to find well-paying jobs. Many of them took jobs that honestly underpaid them. And for them to have to deal with that low base pay haunting them for the rest of their careers doesn't make sense. So I love that particular provision of the bill. And it's really a shame that it was blocked in the Senate because of, yes, the Senate filibuster. And also, even if the Senate filibuster didn't exist, Kirsten Gillibrand didn't even show up to vote for it. Now, also, openly discussing pay with colleagues, again, helps to determine if you or your colleagues are being underpaid. It's an important thing to discuss. Paycheck or pay transparency is an important thing to protect. And this video explains why in a little more detail.
Open salary plans can encourage companies to eliminate pay inequities, including gender disparities, and it's been found to build employee trust as well. Research at Tel Aviv University showed that an open salary plan makes workers more satisfied and more productive. Employees at companies with open plans also spend less time, if any time, trying to figure out what everyone else is earning. And a well-mapped salary scale provides a blueprint for advancement.
So that's in regard to companies that are incredibly transparent about what they pay their employees. They have documents that employees can refer to see how everyone's paid. And so there are significant upsides to that because that transparency, essentially prevents resentment, anger, any type of rift between the employees. And it's the right thing to do. It allows the worker to be able to ask legitimate questions about what he or she is being paid. Now, current law does provide some protections for workers in this regard, but there are exceptions and loopholes. So while in most cases, employers are not allowed to retaliate against employees for discussing their pay, loopholes do exist. It is unlawful for private sector employers to prohibit employees from discussing wages and compensation, and it has been since the National Labor Relations Act was passed in 1935. There are exceptions, and that includes supervisors, agriculture workers, and domestic employees. So even with the current labor laws, employees still punish workers for pay transparency. For instance, as Angela Cornell from Cornell University told the New York Times, it's been the law of the land for many years that employers can't have policies or practices or discipline employees for discussing wages, but that doesn't mean it hasn't been a common practice. Now, again, it's definitely a disappointment that that bill was blocked in the Senate. But there are certain issues in our current economic system, in the way that employees get paid, that were not addressed in that bill. And I want to take a little bit of time to discuss them and draw attention to them. But more importantly, I hope that by telling you guys about this, it'll empower you to avoid signing into what's referred to as non-compete contracts with your employer. Because chances are the non-compete contract is something that is illegal in your context, or more importantly, you can fight back against and ensure that your colleagues are not, bound by these agreements. Now, non-compete agreements, which used to be thought of as contracts between companies and high-paid professionals to essentially protect and guard trade secrets, is now being used for low-income employees. We're talking about people who work at fast food restaurants. We're talking about people who have no access to trade secrets. But this is really just a strategy by the employer to keep wages low and to prevent competition from essentially threatening their revenue and their profits. So non-competes stress or suppress the wages of workers by preventing them from leaving their current job for a similar position at another company that actually pays them more. So it stunts any type of upward mobility for workers. A 2019 study from the Economic Policy Institute found that somewhere between 27.8% and 46.5% of private sector workers are subject to non-competes, which means anywhere from 36 million to 60 million American workers have signed a non-compete agreement in their current job. I'm sorry, but there aren't 60 million executives in the United States who have access to trade secrets and thus they need to sign these non-competes. That's ridiculous. In fact, recent data from the Treasury Department found that about 30 million people, or 1 in 5 workers, is currently bound by a non-compete contract. And around 40% of all workers will be bound by a non-compete contract at some point in their career. As Paul Constant writes in the Business Insider, low-wage workers, including fast food servers, baristas, and even janitors around the country are forced to sign non-compete agreements, even though they don't have access to sensitive or secret information. And you need to understand just how devastating this is for workers. In fact, here's an example for you.
Ochoa came to the U.S. 5 years ago and almost immediately went to work at Allure. I learned everything here.
But 2 years ago, she says her husband convinced her to join him at nearby Canterbury Lampshades, which offered her 50 cents more an hour, but also made her sign a non-compete contract.
They called me into the office and said, here are the papers you need to sign, and if you don't sign, you don't get the job.
She signed, but she says Canterbury failed to give her full-time hours, so she quit and returned to Allure. Canterbury has since sued both Ochoa and Van Wettering for violating the non-compete agreement.
This is so unfair. Forcing people to sign these papers, it's like cutting off our hands because we can't work anywhere else.
Ochoa offered to resign from Allure. Van Wettering wouldn't hear of it. Instead, he filed a countersuit. For the record, Canterbury declined our interview request.
First of all, we hired her originally. We taught her the skills that she has. I can't believe there'd be a judge somewhere in the state of Florida who would agree with my competitor that a person making $9 or less,
$9 or less?
Yeah, assembling lampshades is now subject to a non-compete clause.
So think about how this system is so clearly rigged against the American worker in order to protect the profits of these companies. Non-compete agreements help artificially stifle competition in the labor market, allowing employers to keep wages low by limiting workers' employment options. That's the whole point of using these non-compete agreements. Now, a recent report from the Economic Policy Institute found that non-competes were one of the major factors that over the past 40 years have shrunken the paychecks of the median American worker by roughly $10 per hour. It locks workers in to these companies that underpay them. They're not able to take a better paying job. And sometimes, by the way, these non-compete agreements last for about 2 years after the employee quits the company that they signed the non-compete agreement with. Now, laws regarding these agreements really do vary state by state. There are some states that have completely outlawed them for workers who are not executives, people who do not have any access to trade secrets. But then you have states like Florida, unfortunately, that are pretty extreme in not just allowing non-compete agreements, but enforcing them. Take a look.
In 2012, the Saeeds signed a detailed contract with a private company called LifeShare to take David and Cyrus into their home. LifeShare would train and supervise the Saeeds and also give them a portion of what the state paid for the boys' care. The Saeeds agreed to provide a long list of services.
Robert, sir, this isn't babysitting, this is a therapeutic setting. We're constantly taking data, annotating behaviors, looking at trends, graphing that information. We have therapists coming in and out, we have doctor's appointments.
This level of foster care can be physically and emotionally challenging.
Yeah, I've gotten pushed in the face, he's gotten bitten, he's got nose broken.
You know, we don't take it personal. This is a challenge that they were born with. It's our job to help them manage it.
But according to the contract, the response to violent outbursts was to dial 911, then a LifeShare hotline, and wait for a callback. LifeShare wouldn't comment, but the Saeeds say the company often told them to lock themselves in their bedroom.
What happens if he gets into glass or into some of the kitchenware?
The Saeeds decided to terminate the contract with LifeShare and deal directly with the state, which was urging a more hands-on approach. They say LifeShare immediately invoked the non-compete clause, withholding their monthly stipend and demanding they either give up the boys or pay $20,000 to keep them.
So this is in the state of Florida, where you have a foster family that's bound by a contract that, essentially forces them to do something that's actually harmful to the foster children they're fostering. They decide they want to leave this company that they're working for, but they have this non-compete. Florida actually decided to enforce that non-compete in this particular context, which gives you a sense of really how broken the system is, how ridiculous it is that these laws vary state by state. But there is a solution to it, which I'll get to in just a second. Before I do that, though, even in states where non-compete agreements are outlawed and have absolutely no teeth, just know that companies still try to use them And you should be aware of that because you might be in one of these states that have outlawed the non-compete agreements, but maybe your employer tricked you into signing one that you should not be bound by. Watch.
Non-compete contracts are increasingly unenforceable, but employers keep asking workers to sign these contracts. For example, in California, workers sign non-compete contracts at a higher rate than most Americans, and yet, in that state, these contracts carry almost no legal weight. So what then is their purpose?
Those agreements are just restricting competition and employee mobility, which means you can pay your folks less money and have a better bottom line at the end of the day. That's what it's about. It's greed.
Now, if you think that non-compete agreements are bad, there's actually a type of contract agreement that's even worse, and it's referred to as the no-poach clause in employment contracts. Now, what does no-poach mean? How is it exactly different from non-compete? Well, believe it or not, non-competes are just the tip of the iceberg. There are also these no-poach agreements where, basically, if you work for a franchise, let's say you work for a McDonald's franchise, to give you a specific example, no-poach agreements prevent you from being able to work at a different McDonald's franchise that you might want to work at because it's a little closer to home, it leads to a shorter commute, whatever the reason is. You're not able to go from one McDonald's store to the next as a result of these no-poach agreements. In fact, here's Pennsylvania Attorney General Josh Shapiro explaining what no-poach agreements are exactly and what they do to workers.
We have this setup, this construct in frankly, all across our society today, where the system seems to be rigged against workers, particularly low-income workers. And here's basically how this deal works, right? Steph, you own 5 McDonald's. Allie, you own 5. I own 5. And as part of the deal with our workers, as dictated by the McDonald's franchise, it says that a worker who works for me can't go, Steph, and work at your McDonald's where they might be able to earn a better living, make a few more bucks, be closer to be able to pick up their kids at school because of these so-called no-poach agreements. It holds down the wages of that worker. It holds down the entire economic sector, and it's just frankly unfair.
It is, quite frankly, unfair. And it's unfair and essentially skewed against the worker on purpose. And there are some good people out there who are fighting back against non-competes and no-poach agreements. Now, there's been far more success in regard to no-poach agreements, but it still doesn't go far enough. So I want to turn my attention to, or your attention to Washington Attorney General Bob Ferguson, who has been fighting on behalf of workers who have been tricked into signing these no-poach agreements. As Business Insider reports, this Attorney General requested franchise agreements from every corporation that had franchises in Washington state and found that nearly 300 companies had some form of a no-poach clause. In fact, he says, quote, "We sent them a letter saying basically, you need to eliminate this no-poach provision, not just for your Washington franchisees, but nationwide. Otherwise, we're going to file a lawsuit against you." And so eventually, over the course of about a year, all of them eliminated these no-poach agreements, not just in Washington, but across the country. Now, again, no-poach agreements are different from non-competes, and there still needs to be quite a bit of work done on this issue. So thanks to Ferguson's leadership on the issue, though, the Washington state legislature passed a law in 2019 which voids non-competes for employees who earn less than $100,000 annually. 7 other states have similar laws on the books, but Ferguson notes that non-competes are still legal in the vast majority of states, including Florida. He urges people in those states to talk to your local legislators to take action on behalf of workers. Now, Ferguson's suggestion there is fine, but I would argue that a far better strategy, a strategy that doesn't necessarily rely on the federal government, which of course has proven itself to be dysfunctional, a strategy that doesn't necessarily even require the attention of an attorney general, would be one that actually strengthens labor power. If you have unions, labor unions, actually representing the workers within these companies, then you actually have someone representing your best interests when it comes to these contract negotiations or any type of agreement that an employee needs to sign. A union would be able to discover that there's a non-compete clause within the agreement and fight back against it. And more importantly, a labor union would be able to see that the no-poach clause in these agreements or these contracts could easily be fought back against because they're illegal in most contexts. So look, when we talk about the importance of labor unions, it's not just about being able to organize general strikes. It's not just about ensuring that workers are being paid appropriately for the work that they're doing. It's also about ensuring that workers don't end up signing things that they should not be bound by, that they shouldn't even have to sign to begin with. And it's nice to have someone or an organization, a group of people on your side fighting for you within the company. I think part of the problem is we think, calling our state lawmakers is going to make a big difference, and it could. But again, if you have a union representing you, I think that is going to pay better dividends for the workers than anything else. So we need to organize. We need to unionize. I think that's really the best solution in ensuring that workers get the protection and the pay that they deserve. Nando.
Wow. Yeah. I mean, it's shocking that the Democrats would not show up to pass a bill to help workers. I mean, it's just, the initial flurry around the COVID bailout that was passed in the Biden administration has given way to just a total paralysis and disappointment, and seeing this not how can you not come out and pass a bill when you're the Democrats, eliminating these non-competes. I mean, they're just so comically tyrannical and evil, and just the basic premise that even in our shitty system, a worker can't even leverage his another offer from another company in the same industry to get higher wages. It's absolutely mind-boggling. And that was I didn't even realize that these no-poach clauses. I'd heard of non-competes. I've signed non-competes, in my career. But these no-poach.
But we're different though, right? I thought that it was just mostly on air people and which yeah, and even in that context, I think it's stupid, right? Just let people be free. I mean, I love that I'm able to do this show and I'm not bound by a non-compete agreement at TYT. And they think, it's better to go out there and branch out and talk to people and open up your mind to different ideas. And I love that. And it's made me a better host at TYT. But anyway, that's usually in our context, right? You never heard about it really in the context of a worker at Jimmy John's, which, by the way, when the Attorney General in Washington tried to fight back against these no-poach agreements, Jimmy John's was like, "We're going to sue you. No, we're gonna keep it in place. We're going to fight." Luckily, the Attorney General won that case, and then Jimmy John's had to pay for the legal costs of the Attorney General's office. I think to the tune of $125,000, which is nice.
Very good. Yeah.
Yeah.
I remember part of my negotiations for a network that I was at. It was I settled on salary, all that stuff, but they had this non-compete that I was like, okay, I get that if I leave, if I decide to leave, I could live with a non-compete in this, but they were including a non-compete, if they fired me for whatever reason, and I was like, wait, if you fire me, how am I supposed to be bound by a non-compete? It's not my fault, that you guys decide to fire me. Why would I agree to a non-compete if it's your decision to what am I supposed to do? Just not work? You know what I mean? It's crazy that, just this idea that, it's just, it drives me crazy when I see people kind of buy into the idea of America as competition and all that stuff. And like really what it is it's just like class war on the way, inverted. And it's just like, it's just punishing and making it harder to even eke out a living in the shitty system that we have. It's crazy.
I mean, these major corporations can't even compete against the federal government's unemployment insurance. There's just like, let that sink in for a second. They're complaining about an extra $300 a week for unemployed workers. And rather than maybe discussing, hey, these starvation wages are not luring in employees, maybe we should change that. They're like, no, we got to rig the system, make people desperate to, get paid literally, if you're making minimum wage in this country, it's $15,000 a year. That's crazy. That's absolute insanity. And that's the system we live under. And to be quite honest with you, it would be so easy. Like there's so much public support to change that. And the fact that the Democrats won't do it tells you everything you need to know about how broken our political system is. Yeah, and they suck. Yeah, definitely.
They suck so much. They just suck so much.